Hello everyone, welcome to this video. Today we are discussing about the case Chief Information Commissioner versus the High Court of Gujarat. In this case, the Chief Information Commissioner versus the High Court of Gujarat, the Supreme Court has said that if a citizen wants information from the judicial side of a High Court, he or she has to comply with the respective High Court rules and not the rules prescribed under the Right to Information Act. So first look into the facts of this case. An RTI application dated April 5, 2010 was filed by the respondent number 2 seeking information pertaining to the cases Civil Application number 5517 of 2003 and Civil Application number 8072 of 1989 along with all relevant documents and certified copies. In reply, white letter dated 29 April 2010, Public Information Officer Gujarat High Court duly informed the respondent number 2 that for obtaining required copies, he should make an application personally or through his advocate on affixing court fees stamp of ₹3 with requisite fee to the deputy registrar. It was further stated that as respondent number 2 is not a party to the said proceedings, as per Rule 151 of the Gujarat High Court, Rules 1993, his application should be accompanied by an affidavit stating the grounds for which the certified copies are required, and on making such application, he will be supplied the certified copies of the documents as per Rules 149 to 154 of the Gujarat High Court Rules 1993. Subsequently, the respondent number 2 preferred an appeal barring number 84 of 2010 before the appellate authority registrar administration under section 19 of the act, which was dismissed while on order dated 4/8/2010 on the ground that for obtaining certified copies, the alternative efficacious remedy is already available under the Gujarat High Court Rules 1993, and that under the provisions of the RTA Act, no certified copies can be provided. Respondent number 2 then filed a second appeal number 1437 of 2010 before the appellant Chief Information Commissioner, and relying upon the section 6 clause 2 and 22 of the RTA Act, the appellant Chief Information Commissioner, while its order dated April 4, 2013, directed Public Information Officer of Gujarat High Court to provide the information sought by the respondent number 2 within 20 days. Subsequently, Special Civil Application number 7880 of 2013 was filed before the High Court, wherein the learned single judge passed an interim order dated 11 October 2013 directing the respondent number 1 to provide the information sought by respondent number 2 within 4 weeks. Being agreed with the interim order, respondent number 1, High Court of Gujarat, preferred letter patent appeal number 1348 of 2013 before the division bench, which set aside the order of the Chief Information Commissioner by observing that when a copy is demanded by any person, the same has to be in accordance with the rules of the High Court on the subject. The Honorable Bench, understanding that the issue is hand concerns all the High Courts, requested Mr. Atmaram N.S. Nadkarni, Additional Solicitor General, to appear as amicus curiae to assist the court, entrusting him with the responsibility of collecting and compilation of the information obtained by him from various High Courts about the rules framed by various High Courts in exercise of their powers under Article 225 of the Constitution of India and under Section 28 of the Act. Now, let's look into the issues raised in this case. The first issue was whether Rule 151 of the Gujarat High Court Rules 1993 stipulating that for providing copy of documents to the third parties, they are required to file an affidavit stating stating the reasons for seeking certified copies suffers from any inconsistency with the provisions of the RTA Act. The second issue was when there are two machineries to provide information or certified copies, one under the High Court rules and another under the RTA Act, in the absence of any inconsistency in the High Court rules, whether the provisions of the RTA Act can be resorted to for obtaining certified copy or the information. Here, the major issue was between the consistency between the rules and the Act. So, let's look into the submission. First, look into the submission preferring the RTA Act over the High Court rules. Section 6 Clause 2 of the RTA Act specifically provides that an applicant making a request for information shall not be required to give reasons for requesting the information sought. Where under the Gujarat High Court rules, application made by the third parties seeking copies of the documents shall be accompanied by an affidavit stating the grounds on which they are required. Thus, there is a direct inconsistency between the provisions of the RTA Act and the Gujarat High Court Rules 1993. Now, second one, the Section 22 of the RTA Act specifically provides that the provisions of the RTA Act will have an overriding effect over any other laws for the time being in force. Now, let's look into the submission that highlights the consistency between the RTA Act and the High Court rules. It was duly submitted that the respondent number 2 was informed to make an application as per the procedure stipulated under the Gujarat High Court Rules 1993, and since he was not a party to the proceedings, he was informed that his application should be accompanied with an affidavit stating the grounds for which the certified copies are required. The High Court rules and the RTA Act are in consonance with each other here. After hearing the contentions of the parties, while examining the first issue, the Supreme Court held the Rule 151 of the Gujarat High Court rules stipulating a third party to have access to the information or obtaining the certified copies of the documents or orders requires to file an application or affidavit stating the reasons for seeking the information is not inconsistent with the provisions of the RTA Act, but merely lays down a different procedure as the practice or payment of fees, etc. for obtaining information. In the absence of inherent consistency between the provisions of the RTA Act and other law, overriding the effect of RTA Act would not apply. The information to be accessed or certified copies on the judicial side to be obtained through the mechanism provided under the High Court rules. The provisions of the RTA Act shall not be resorted to. The information held by the High Court on the judicial side are the personal information of the parties and hence cannot be disclosed under the RTA Act. So far as persons who are not a party to the proceedings are concerned, the court held that such a person can obtain the certified copies or can have access to the information under the High Court rules only after filing an application or affidavit stating the reason for which the information or copies of the documents or orders are required. It was held that and stipulation does not suffer any inconsistency with Section 6 Clause 2 of the RTA Act. The bench further held that the information held by the High Court on the judicial side is personal information of the parties to the litigation or information furnished by the government in relation to a particular case. The information is held by the High Court as a trustee of the litigants in order to adjudicate upon the matter and administer justice, and hence such information can be shared to the parties to the proceedings only under the High Court rules and not under the Right to Information Act, the court held. For persons who are not a party to the proceedings, Such information or certified copies can be given only under High Court rules provided the competent authority is satisfied that the information is sought for bona fide reasons or to effectuate public interest. Scope of the personal information under the RTA Act. While examining the other issue regarding the availability of two mechanisms to obtain the information, the court appreciated the view taken by the Delhi High Court in the case the Registrar Supreme Court of India versus R.S. Mishra, wherein it was held that once any information can be accessed through the mechanism provided under another statute, then the provisions of the RTA Act cannot be resorted to. Accordingly, the court held that when the High Court rules provided for the mechanisms that the information or certified copies can be obtained by filing an application or affidavit, the provisions of the RTA Act cannot be resorted to. The provision of the Gujarat High Court rules mandating filing of affidavit with application stating the reason for which information or copies are sought is not inconsistent with the Right to Information Act. Now, looking into this judgment, we can come into a conclusion that the judgment overturned a fundamental principle of the RTA Act, that no reasons are required to be given for requesting information under the Act. This judgment is likely to have a very negative implication on the citizens' fundamental right to information.